Well, how do you guys work? I don't know. If we just want to do the bond, I want to be asked if she's willing to do that. It's a surety bond, right?
Yeah, we just, we can go talk to her right now.
Let me talk to her and see. 50,000?
But the judge, I mean, I don't know, but the judge.
What would you
That's
say?
gonna be my recommendation.
50,000.
We want to.
Yeah, and this, that stipulates the state on that one.
You guys can
Since,
talk.
you know,
Yeah,
work right there,
and it was
Let me ask her.
a lot,
yeah,
a line.
just want to, we appreciate that. I just want to make sure.
Thank you, sir.
Frank, I stand by that update for you, so.
Can I go back to manager?
All right, so Ms. McCauley's coming from Ms. Dorfman's case. Looks like we've got,
Yes, Judge. I just spoke to Deputy McCauley. She advised she is on the way down. I don't see her in the courtroom yet. Attorney Fuller wanted to go back and talk to her client. We just had an opportunity to talk.
we got Mr. West here. Now, Mr. West is only handling one, so.
Okay, we can move forward with Deputy McCauley's case now. She just came in the courtroom. That's position
Hi,
one.
Judge.
Okay.
Yes,
Thank you, McCauley.
and I will have updates on the other cases in the meantime. Yeah.
Hello, Deputy McCauley. This is Tracy Dorfman.
Oh, hello, Ms. Dorfman. Nice to meet you.
Nice to see you. And I just sent you a text asking about a waiver of prelim with a high bond and special conditions in this case.
If you can just give me one.
Sure, sure.
Outside the realm of possibility, and I apologize, Judge, for being a little.
No, that's okay. I mean, I had to take care of ex parte.
I'd like to speak to Detective Allen, just real quick about the request for bond. I did review the case. I am familiar with the circumstances. I reviewed the defendant's GCIC as well.
So again, if you want an ankle monitor, that would be fine as well.
So we can release them. Okay, actually, Judge, the state's gonna go ahead and consent to a bond. After I've had the opportunity to speak to Detective Allen. My concern was that the defendant was gonna be released back into the residence where the child is, and that's not an issue. I can.
Yeah, I put it on there, what y'all agreeing to?
Yes, I'm reviewing Miss Dorfman's request. I don't have an issue with it. The request is $25,000 per count for a total of $75,000. There'll be a no contact order with the victim. His criminal history, Judge, just to be perfectly candid with the court, he does have a prior attempt to commit murder, but it's from 1994, I think. So not necessarily a good temporal proximity for the state to make an argument that he should be on an ankle monitor or a curfew. We would just require no unsupervised contact with juveniles under the age of 16.
I typically do that just because it's short. Where's he gonna live?
Your Honor, I'm sorry.
No, go ahead.
His address is 4018 Dinmont, Dinmont Chase, Atlanta 30349. His wife has moved out of that residence, so she will not be there.
Okay, so the alleged victim up, so he can actually go back there.
Yes, he can go back, Judge, because the wife is living in Decatur. Let me look at the conditions of her bond really quickly and just make sure that we don't need to have any cross conditions
Okay.
on her bond.
I believe she's not allowed to have contact with him.
So that was gonna be my suggestion, Ms. Dorfman, is that we have a no contact order in place for him as well.
See, what's the wife's name?
It
Her name
is,
is Danielle Henriquez.
it's HENRIQUES.
And Ms. McCauley, the only glitch at all, and I know she's represented, I believe, by Ryan Brown,
Yeah.
is that the two of them have this hauling cars business. They haul cars to auctions around the Atlanta area. that they own together. So that's the only glitch. I don't know if there's any way they can still at least operate their business without living together, or.
I mean, if we need to include a provision for a third party, I'm happy to amend the bond. If that is identified as an issue, obviously we don't have that information present before the court right now.
Okay.
But if we need to do an amendment allowing for contact via a third party, that's fine.
I'll put the ankle monitor on there with the 24-hour curfew except for court, lawyer, medical, and work.
Perfect. Thank you, Judge.
Of course, Ms. Dorfman, that means it's deals by itself.
I'm sorry, I couldn't hear you, Judge.
I said I'll put it on there with the 24-hour curfew except for court, lawyer, medical, and work. And what that means, like, obviously he's gonna need to go to the grocery store. If he goes to work, he can go like 1 mile out of his way, go to the grocery store and go home. Like basic daily activity.
Okay, so I think you might need a time on there that he needs to be home in the morning and that time to be home at night, because I think this is one of those, there's jobs. So I don't know if you want
As long
him.
as he supplies you with the schedule.
Yeah.
Like this week I've got car auctions, since it's kind of fluid. I've got car auctions on
Full
this day.
disclosure, Your Honor, and Ms. McCauley, I am only hired through today, through the bond / preliminary and/or prelim. So I will not be having contact with Mr. Jordan after this, is once he's, posted this bond.
He's gonna have to let whoever he hires.
Okay,
Directly let the state know and the ankle monitor company where he's going, what he's doing, how long.
okay, all right. So I know he plans on hiring another attorney after today.
Okay. Are you gonna just submit that, Ms. Dorfman, to Ms. McCauley, and then y'all send it to me? Okay.
Yeah, that's fine.
Or whichever, or I mean, okay. All right, so is he in there? Do you want him in there, Ms. Dorfman?
Is he, I was gonna say, did he hear any of this?
Now, can we bring him out, Samuel Jordan, deputy?
I'll just briefly tell him what the bond is.
What was the name, Judge?
Samuel Jordan.
Thank you, Ms. McCauley. And thank you to investigator Allen for sure.
Yeah, she's awesome.
I know. I did speak with her a long time ago about this case. So, but she is terrific.
We will try to keep her as long as we can.
Are they at the jail or are they being brought into the courtroom?
They're gonna be brought into the courtroom. He'll sit right there at the table where it says,
Okay, so I'll just tell them real quick so y'all can get on.
yeah. Here, that should be him,
Yeah.
right? Okay.
Hi, Sam. Can you hear me? This is Tracy Dorr. Okay, so the state was gracious enough to consent to a bond in your case. It's 25,000 per warrant, so that's a total of 75,000 regular bond. You will have a curfew for, that you can work during the day, but you will have a curfew. Obviously, no contact of any kind with Janiyah, who is living in Massachusetts, but no contact of any kind. Also, I believe Ms. McCauley said no unsupervised contact of any kind with anyone under the age of 16. And you will be placed, an ankle monitor will be placed on you before you are released from the jail. Do you understand?
Yeah.
Okay, and you also understand that my services are now completed with you, and you do plan on hiring a new attorney from today on, correct?
Yeah.
Okay. Anything I missed, Ms. McCauley?
So Mr. Jordan, it's basically called a 24-hour curfew, but you can leave for court, lawyer, medical appointments, and for work. So until you get a lawyer, I mean, it's kind of a weird position because you have to let the ankle monitoring company know that, hey, I'm going to work. I'm going to this address. I'll be there for, 2 p.m. to 6 p.m.
But I do drive food trucks.
Hold on. You've also got to communicate that to the state. So that's why I'm saying.
Yeah, you need to hire an attorney as soon as possible.
Right. Because of course, I'm sure you don't want to communicate with Ms. McCall. Although she's a nice lady. Probably not your best friend. Okay, so as soon as you get a lawyer, so when you get that ankle monitor put on, sir, if you're not telling the state where you're going, they're going to consider that a violation of your bond. So you need to go hire a lawyer yesterday that you're going to keep the whole time. Okay. You can also have no drugs unless prescribed, no alcohol, and no weapons. You can't be around a weapon. You can't get in the car with somebody who's got a weapon. Okay, and you can't have, any contact with your co-defendant, okay?
Yeah.
And you can speak with Ms. Dorfman, y'all can work out something about a third party to communicate as far as, I know you guys own a business together or something, but the two of you don't need to have any sort of contact. I'm sure that her lawyer doesn't want you contacting you, and Ms. Dorfman or whoever you hire after this isn't gonna want you contacting her. okay?
Yeah, so, Sam, yeah, I will call your wife's attorney and let him know that they are going to need to find a third party that can communicate between the two of you for work purposes, okay?
All right.
All right, best of luck to you, sir.
All right.
Thank
Thank
you,
you.
Mr. Raleigh. Thank you,
Thank
Ms.
you.
Dorfman.
And I'm sorry, is Ms. McCauley sending me the bond order or?
I certainly can. Ms. Dorfman, I can write it up this afternoon and send it over to
Okay.
you, and we'll get it signed.
Okay, perfect. And that will be generated to the jail, correct?
Yeah.
Okay, and so Mr. Jordan, remember, you will not be released until you're fitted with that ankle monitor, okay?
All right.
All
And
right,
is that gonna be county paid, Judge, or is that gonna be self-paid?
What would you prefer?
I mean, he's gonna post a $75,000 bond.
I don't think he's gonna have the money.
I'll go with county paid for right now.
Okay,
We'll go with county paid right now, sir. However, they can modify it later, and make you pay for it, okay? Because we have this little pool of funds.
so just make sure you do not do anything without the ankle monitor company knowing exactly what's going on, okay?
All right.
All right,
Yeah, if you're
very
gonna go
good.
to work and stop by the grocery store, say, I'm leaving my work, I'm gonna stop by a Kroger, but you can't go to a Kroger at Perimeter Mall, okay? You stop by something on your way home, okay? And Ms. Miller, you can go ahead and put these in 70 days without 70 days, Ms. McCauley, without indictment.
Yes, I will. I'll put that on
Ms.
the order.
McCauley sends it to me, I'll sign it and send it back.
I will. Thank you, Judge.
Thank you, everybody.
Both,
Hey, may I be excused?
yes, ma'am.
Okay, thank you all. Take care, everybody.
Right.
Thank you.
Thanks again, Ms. McCauley.
Of course, thank you.
We'll leave one out next there.
Wipe down my party from the table because I'm sick. I don't like
Thanks for coming down.
No, we'll get everybody else. It's a lot for us to do.
I appreciate y'all working. with me. I'm trying to get y'all to notice and everything.
I know.
So,
No,
yeah,
I
yeah,
appreciate you
yeah,
guys
yeah.
following up. It's just a lot for us. We'll figure it out.
Thank you. Let me know if you need me to follow up on anything as well. All right.
I think Jasmine's gonna cover the rest of it. Hey, how's it going?
Okay.
So, Mr. Norwood, you found out anything about James Smith, since Mr. Clement's here, and Miriam?
I am still,
With that, since Mr. Johnson.
I do not have an update yet, Your Honor. I'm reaching out to Investigator Pauls, and I'm also going through our sheets to see if any of them are on approved leave right now. I don't see their names on that list yet, but I should have an update soon from Investigator Pauls about, for James Smith, it's APD Officer Campbell, and for position 3, Olu Muja, that is Sandy Springs, that's Beatley. We have our other Sandy Springs officer here, though. That is Davidson. Do you know anything about?
Is position 4 one of the public defenders?
Position 4 is Cornwall. That is Attorney Cornwall. That is not a public defender.
So it's
That's
not
my
one of the- Okay, because sometimes I like to take them because I know they have to work at night.
I'm not sure if they filed a entry, but I was advised that David Houston, who may be attorney of record, he is in Judge Drake's courtroom right now.
Okay. All right, well, we got Mr. Clement, we got Mr. West. I don't see anyone on here named Cornwall.
She's in the courtroom, and Attorney Houston is here as well.
Okay. Call one in. Who wants to go? Let's get it going.
I have 1 second to discuss position 6. I think we're ready to move forward on a bond hearing for that one.
Yeah, but she does not meet.
It'll be a curfew in a couple months. I'm recommending it.
And you'll be okay with the state thing about monitoring service?
That's fine.
Okay.
Mr. Norwood, Mr. West sent you a message in the chat.
I am going to reply to that one now. As far as what we can do moving forward, I believe me and Attorney Fuller are ready to move forward with a bond hearing. I believe Attorney Fuller is choosing to waive the bond hearing and have Your Honor set bond.
Okay.
That's all.
64 days, position 6. Y'all want to bring out Destiny Manning? Deborah?
Not yet, not yet.
She's waiving the prelim?
Destiny Manning, yes. Thank you.
You said she's waiving the prelim?
Yes, my understanding is, yes, she is waiving the prelim. And Just proceeding on bond today.
So is that officer there? Do you want to let that officer go?
We can let him go if, yes, Officer, the Investigator Davidson is here. We appreciate him being here. Yes.
Thank you, Judge.
Thank you so much, investigator. Stay safe out there.
See you next time.
Thank you. Have a good one. We do have Officer Frank here for positions 4 and 5, and after this, we can take up those, and I will perhaps have more information about 2 and 3 by then. I'll look for Mr. West's information. Now, I think Mr. West is wanting to address bond today as well. That's my understanding, but he may have other information.
Okay. And you'll let, so Mr. Clement can know too, and Mr. Johnson.
Oh. What's going on?
You got a private on 4.
I believe it's Cornwall over there with the.
The landscape.
Yeah.
Y'all ready?
Yeah, we ready, Judge.
Okay, just wait. All right, so this is position 6, Destiny Manning, 22 CP 214469. 64 days without indictment, got armed robbery, ag assault, false statements, and obstruction misdemeanor. Like I said, 64 days without indictment. It's my understanding, Ms. Fuller, you're going to waive prelim. You just want to be heard on bond, correct?
Yes, that's correct, Your Honor.
All right, let's see. Is Ms. Mann here? Yeah.
Judge, we're asking, I think the state is offering a $50,000 bond. It's a little high for my client. We're asking that the court set a bond limit of $50,000. My client is 25 years old. She has 2 minor children that she's solely responsible for, Your Honor. And prior to being arrested, she was working 2 jobs. One part-time and one full-time job. She's a sole provider of those children. Right now, her mom is sort of filling in the gap, but of course, she's been here since December. We're asking that she be allowed to go home on bond. She is willing, Judge, if the court is inclined to reducing the bond amount, she's willing to do house arrest so that she's able to be at home with the minor children.
Hold on, let me interrupt you. Do you see a bond? Because right now, what I see is no bond.
There's no bond right now, Your Honor.
No. We did talk about waiving the prelim, and the state said they would offer a $50,000 bond.
My recommendation would be in the range of 50,000. Yes.
Okay, I'm sorry. It's a little bit hard when you're at that table. I don't know why. They said they would offer what?
A bond in the amount of 50,000.
My what was that?
50,000 total?
No, yeah, it would be no lower than 20K on the armed robbery, nothing lower than 15,000 on the aggravated assault. I was going to ask for $5,000 each on the false statements, but that last false statement is the same as the willful obstruction of law enforcement officers, where the defendant didn't provide accurate information about where the vehicle used to get away was. So we would ask for $1,000 on both of those. No further contact, of course, with the Marcellus Brooks. And I did want to hear what the record was as far as no weapons and ankle monitor and things of that nature.
We got Miss Mann. She's pulling double duty today. Pre-trial. You there, Miss Mann? This is on the Destiny Manning.
You're on, which position are we on?
6, Destiny Manning, no relation.
Position 6, okay, and I'm sorry, you may hear a little background, I'm in another court as well.
That's okay.
So let's see, position 6, Manning. Okay, Your Honor, there are. In Georgia, there are 5 cycles, Your Honor. They are, and I'm not sure if this is the one we're here on today, but 32421. There is a reckless conduct. That case is still showing open in GCIC. On 9/10/19, theft by shoplifting, probation 12 months. 9/24/19, theft by shoplifting, convicted. That's the probation, Your Honor. That's 12 months. There is a 9/6/18 battery, not on docket, Your Honor. Was bind over on 9/17/18. The not on docket was on 4/27/20. 4/29/18, tampering with evidence, NOLO. On 9/25/18. And then there's not a date on this one, but it's showing tampering with evidence, probation 12 months, according to GCIC.
All right. Thank you, Ms. Mann.
There is 7/19/15, unauthorized discharge of firearms within 50 yards of a public highway. First offender that occurred on 5/16, probation 12 months. And let's see, it looks like there was another state. I think I just want to make sure that it wasn't. It is not. That concludes everything, Your Honor.
Thank you, Ms. Mann. You can go ahead
You're
and go back.
welcome.
All right, so Ms. Fuller, the address that we have here on file is a Rex, Georgia address. That's where she's going to live.
No, Judge, I think she has a local address. 120 Memory Lane in Stockbridge, Georgia.
Stockbridge, okay, so Henry County, okay. All right, I'm sorry, you were a little bit, so go ahead with your, so he said basically 20, 15, 15, 5, 5, 1, and 1. That ends up being 77,000.
Yes, Judge, that is the state's request.
Okay.
I'm sorry.
I understand that was 62, 20, 15.
Say those numbers again.
77, I mean, you said 5,000 on 2 of the false statements, 1,000 on the last one, and 1,000 on the threat.
Yeah, I got 20,000, 15,000,
Maybe I
15,000.
think I put an extra 15. Okay, yeah.
Okay, yeah. Then I had
Yeah, I put an extra 15, so it's $62,000 good bond.
yes, Judge, that is the state's recommendation, particularly given the open probation and the prior tampering. misdemeanor conviction, we would submit that as extraordinarily reasonable. I advised I would ask for nothing lower than $50,000 when speaking with Attorney Fuller. If Your Honor is inclined to go less than 5,000 on either the false statements, I would advise one of the false statements was advising investigator Davidson that she worked at a Walgreens when she did not. And one of them was that she was not at the location, the incident location when she was. It was an extensive probable cause statement, and we did both have an opportunity to speak briefly with Detective Davidson about this case.
Okay, so go ahead, Ms. Fuller.
Judge, we're asking, obviously, we're asking for a lesser bond than the state is recommending. She has had some issues, Judge, but she has maintained some employment. She's raised her children by herself. And right now, the children are home without her, Judge, no parent. And we're asking that if the court were inclined to set a lower bond, she's willing to do house arrest, no contact with the victim, no contact, I believe there's a co-defendant, no contact with him. And she will be in court when the court requires her to be, Your Honor.
All right. Is there a co-defendant in this? Because I'm trying to look over this really quick.
Marcellus Brooks is a co-conspirator.
Okay, co-conspirator. Okay. That's what I was. Okay, no drugs unless prescribed, no alcohol, no weapons. Stay away from 5690 Roswell Road, all Metro PCS stores. No further contact with the alleged victim, and that is Muharrir, last name Joudeh. No further contact with your co-conspirator, Marcellus, Marcellus Brooks, Brooks. You're going to stay out of Fulton County unless you're here for court or to see your lawyer. Can have an ankle monitor with a 24-hour curfew except for court, lawyer, medical.
Just very briefly, Your Honor, there's one more victim. He was also in the store at the time. It's Andres Santana. It's Andres. Santana is Santana. He was also an employee of the Metro PCS. He saw the firearm.
Thank you. No further contact with Andres Santana. Sorry, I'm kind of going through this as quick as I can. Usually I do this during the prelim so I can write it down.
Yes, Judge. Yes.
So that'll be paid for by the county, ma'am. The only reason you come back to Fulton County is go to court or to see your lawyer, okay? Fill up a gas in Stockbridge, come to Fulton County. Do not run out of gas in Fulton County. Don't get a flat tire in Fulton County. If you do any of that, ma'am, that's a violation of your bond conditions, and you will sit in Rice Street or what is ACDC until your trial. You understand? You have, when you're going to go to the doctor or something like that, you have to let the ankle monitoring company know and your lawyer so that she can let the state know where you're going. Now, ma'am, is she going to live by herself or is she going to live with family, Ms. Fuller?
She's probably going to live with her family, Judge.
Okay. All right. So, ma'am, if you have to go to the doctor or something like that, please let them know. And I see on here before, it says something about maybe talks about a parole. I don't know. If you've got some sort of legal appointment like that besides your lawyer, ma'am, you can also leave. You just have to let the ankle monitoring company know where you're going and Ms. Fuller so she can let the state. All right? And no further contact with your co-conspirator, no further contact with those. You can't go to any Metro PCS stores. Ma'am, if your phone is paid for through Metro PCS, get somebody else to go in there and pay the bill. You cannot go in there and pay the bill. Best of luck to you, ma'am.
What was the final amount, Judge? I'm sorry.
Go ahead and go with this, what the state said. 20, 15, 15, 5, 5, 1, and 1. 20 armed robbery, 15 on each ag assault, 5 on 2 false statements, 1,000 on the last false statement, 1,000 on the misdemeanor obstruction. And Ms. Miller, if you could put on there that was the bond amount that the state recommended, please, for me.
That's fine.
Thank you, Judge.
All right. Thank, good to see you, Ms. Fuller. All right, now who are we going to take care of?
Yes, we can do the bond hearings on 4 and 5, and I'm not sure what Attorney Eric Johnson wants to do on position 3, but I do have an announcement for Your Honor that it's Beatley, Officer Beatley on position 3. He is on approved leave until February 7th. So we would ask for Eric, if Attorney Johnson is wanting to move forward with a preliminary hearing, we would ask for a reset until the officer is off of approved leave.
Your Honor, we would oppose any reset. We didn't set the calendar. This matter could have been set down when the officer was not on any approved leave. We are ready to proceed with the prelim as well as bond in this matter. These matters were filed quite a while back. My client has been in jail for 67 days, I believe. Her case is still not indicted. So as such, we're here and ready to proceed, Your Honor, on the prelim as well as bond.
Sorry, hit that mute button. So how do you know that when it was put on this calendar, the officer was not, or had not already signed up for approved leave?
Sir, I know we've received this calendar like a week ago, so it takes a lot of logistical information, logistics just to get the information that they're on approved leave. So I'm not certain.
Mr. Johnson out.
Oh, okay.
But he had not already had his leave. I mean, here's the thing, Mr. Johnson, and I appreciate your argument, is that one, when I say my office, Miss Lewis, Miss Watts, Miss Robinson, it would have been Miss he abandoned us. When they set these calendars, you know, all they really do is email me and say, are you available? Or Judge Dallas or Judge Mann, and say, are y'all available? They don't really reach out to the DA, any public defenders, any attorneys, or any officers. So that'd be way too hard. So if he's on approved leave, I'll typically give it one reset. And don't worry, Mr. Johnson, because if there's another time when they don't show up, if they're not in leave or on training, I'll make a phone call to the chief if they work for APD and make sure they get a few days off without pay. I think it's ridiculous when they're going to arrest somebody and don't show up. But if they're training on approved leave, we all need a day off. So what's your position? How far out do you have any sort of leave yourself, Mr. Johnson, that's out?
I'm actually on the YSL trial, Your Honor. The only reason I'm able to be here today is because we broke early today. Yeah. So I'll be caught up for the next 4 months.
4 months, you're easy going, Mr. Johnson, because what I hear is longer than that.
I mean, we've already been doing it for 2, so 4 months would make it 6 months.
Yeah, y'all are still just dismissing the hardship. So I know sometimes it's only 4 days a week. Do you have a day already in advance that you know that they're not going to have it?
No, Your Honor. We have not sat down. As you stated, we're still discussing the hardship, so the actual trial schedule has not been set as of yet.
So is there a day that he's not? I know some days he won't bring in any of the jurors for some reason, or only he brings them half a day. Does he do that on Fridays, or what is he?
Well, potentially we've been speaking about a schedule in which we would have Fridays off, but that has not been set as of yet. So I could not give the court any direction with regards to which Fridays that we would have off at the present time. And another reason is that, I mean, I'm definitely prepared to deal with the bond matter today. I just don't want my client sitting in jail for an extended period of time just for me to get back to another court date. So, I mean, given that the officer is not present here today, that's something that definitely we can take into consideration with regards to the bond hearing in this particular matter, Your Honor. I have the victim in the case is on the call, my client's husband, and so we were more than ready to proceed, definitely with at least bond today, Your Honor.
I mean, I'll give one reset. Do you want me to? I can try to put it on a Monday or a Friday, or put it at least in the afternoon. I mean, if you think that there's one day that an afternoon calendar is better, we can set it out like a couple of weeks. I'm trying to make it. I know you guys are going to be tied up for a really long time.
Well, Your Honor, I think that I would rather have that discussion after we conclude the bond hearing, because if my client gets a bond that she's able to make, she won't be in jail for a preliminary hearing anyway.
Okay, so if you just want to reach out, I guess, so you want us to hold off on the reset date?
Until we have the bond hearing, then we can discuss it after the bond hearing if it's necessary, Your Honor. If the bond comes within what I've spoken to the family about, they're able to meet, I anticipate she's going to be out of jail as soon as the bond is posted. So then the preliminary hearing problem will be moot at that point.
So Ms. Watts said there's February the 27th is like, February. Just keep that in. All right. Do we have Ms. Mann back yet, or is she still in the other court? We have Ms. Mann.
I believe, you're asking who do we have up right now, Your Honor?
We're going to do this bond hearing real quick, I guess, but Ms. Mann, I know, is popping back and forth between 2 courtrooms. I guess Bostic probably called out sick. We know how Bostic can Ms. Lewis, I guess you'll let Ms. Mann know. I can go ahead and put this on the record and Ms. Mann can tell us. So we got position 322 CP 214 Miriam. Oh, you want to bring her out? Miriam, how do you say her last name, Mr. Johnson?
Wilson Olamoja.
Olamoja. Can we bring Ms. Olamoja out, Deputy?
Yes, Judge. We have a position 4 out, so I think they're going to take him back and bring the other one back up now. Yes.
Okay, sorry about that.
Yeah, we just moved to that one because of the fluidity of everything. Appreciate y'all.
What about Mr. Clement? Have you spoken with him about that officer in position 2, Mr. Smith?
I sent Mr. Clement a chat. I don't have an update on Campbell yet. That case is somewhat dated, so there might be a logistical issue there where we haven't been able to confirm whether Campbell is still with the Atlanta Police Department. But I don't. That's not my update. I'm still waiting to hear back.
Okay.
You did get my chat though, right, Attorney Clement? Oh, I'll send it.
I did not get a chat.
I'll send it to you.
Okay.
Mr. Johnson, did you already talk to Mr. Norwood about a consent and see what he would say or no? Really?
I based on my client's criminal history, I had suggested a UJR. The state indicated that they would not be able to approve that matter. So that's where we are, Your Honor.
Okay. All right, we'll go ahead. We'll put this on the record at least till Ms. Mann gets here. So we got 22 CP 214452 Miriam Nosen Ulamoja. Ma'am, I'm sorry, I probably messed that up. Right, 66 days without indictment, unlawful to come inside door lines to deliver, inmate, a controlled substance, etc. Possession of marijuana less than an ounce and aggravated assault. I wrote this man here. Official answer.
Okay, Your Honor, which position are we on?
Position 3.
Position?
Miriam.
Okay, I want to try to pronounce that last name. Miriam is the first name. Okay. Looks like in California, there are 4 prior histories, Your Honor. That is 5, 18, 20, vandalism. GCIC, NCIC is showing that case still open. 52520, force, not firearm. Disposition says relate, detention only, others. There is a 41119 DUI alcohol with drug. That case was convicted and that was placed on probation. For the Las Vegas, there is 1 cycle, 12819. False, and I'm not sure what this is. I guess it's statement, false statement to obstruct public officer. That case is still showing open in GCIC, NCIC. Again, that was 2019. And I want to verify that there is no Georgia history here. And it is not, Your Honor. That concludes my histories.
Thank you, Ms. Mann. You can go back to the other one. So I got like Mr. Foxworth.
Yes, Your Honor. Mr. Foxworth is the alleged victim and Miss
Mr. Foxworth, if you plan on,
Olamoja's husband.
okay, stand by. Mr. Foxworth, if you plan on testifying, you have to turn your camera on. I have to see your face.
Okay,
Yeah,
it says you cannot start your video because the host has disabled it.
start your video. We just hit.
Okay, there it is. I got it, Judge.
All right, now, Raise your right hand for me.
Wait a minute, I'm still,
Your
okay,
video's on. Just raise your right
okay,
hand. You swear-
okay, gotcha.
You swear firm testimony about to give is the truth, whole truth, nothing but the truth.
Yes, Your Honor.
All right, so I don't need you to say a single word, Mr. Foxworth, until we call on you, okay?
Yes.
All right, go ahead for your bond order, Mr. Johnson.
Yes, Your Honor. Before you today is Miss Miriam Olumoja. She is a resident of the state of Georgia. As indicated by pretrial, she has no prior Georgia history. She does have some history. She was a former resident of the state of California. Mr. Foxworth, who was on the camera, is her husband. They have been married. They have been married, I believe, for the past 9 months. They both are Georgia residents residing in the Atlanta metropolitan area. Miss Olumoja was given conditions that she was not supposed to have any contact with her husband, Mr. Foxworth, in this case, Your Honor. They have agreed that if Miss Olumoja is released, Mr. Foxworth will leave the marital residence and go reside with his mother, who lives in the Atlanta area. So that there will be, but we do want no violent contact in this particular case, Your Honor. We do not believe that she is a threat to intimidate any witnesses in this matter. As you see, Mr. Foxworth is on the calendar, on the camera, and more than willing to state that he has no fear of his wife in this particular matter. So we do not believe that she's a threat to intimidate any witnesses in this case. As based on her criminal history, she has no felony convictions. I do not believe, based on what I heard, the last conviction being one out of Las Vegas in 2019 for false statements, which is not a violent offense, Your Honor. I do not believe that there are any, I've not given any information regarding any additional witnesses in this case, so the state cannot allege that she is a threat to it. Frustrate the administration of justice anyway. As pointed out, Your Honor, as the rest stated by her criminal history, she does have charges from other jurisdictions outside of the state of Georgia. However, there is no showing of any failure to appears on those matters, Your Honor. So it's safe to say that even though she does have a charge out of Los Angeles and a charge out of Las Vegas, that she has appeared when necessary for these particular matters, as which she will do in this particular case, Your Honor. So as such, Your Honor, given the limited criminal history of my client and the lack of the Faretta factors in this matter, she has no failure to appears, which would indicate that she's going to come back to court, nor was it recited that she had violated her probation on the Las Vegas case in any way. So we do not believe that's an issue before the court. She is currently, while she is not employed right now, she is currently a student, Your Honor, at the National Academy of Sports Medicine, attempting to get a degree in physical therapy, Your Honor. So she wishes to get out to get back to that as well. So as such, Your Honor, we do believe that she is a candidate for a reasonable bond in this case, and we would ask for a bond not to exceed $15,000 in this matter, just for a slight factual basis in this matter, Your Honor. Based on the charges, the aggravated assault, Mr. Foxworth is the victim in that case. And I believe the other two charges are based on some marijuana that was on my client's person at the time she was taken into custody, rather than any intent trying to smuggle something into jail for another inmate, Your Honor. I do believe that this is something she had on her person when she was taken into custody. So for the foregoing factors, Your Honor, we do believe that my client is a legitimate candidate for a reasonable bond in this case, and we would ask for a bond not to exceed $15,000 total for all charges. Thank you.
What says the state? Do you want to hear from Mr. Foxworth first, Mr. Norwood?
Yes, Judge, we can.
So Foxworth,
Yes, Your Honor.
the Hammond Drive, you're gonna move out and allow her to live there.
Yes, Your Honor.
Okay, and are you asking this court to make it no further violent contact?
No further violent contact.
And just for clarification, Your Honor, the address in which Ms. Olumoja will be staying is the 795 Hammond Drive address in Sandy Springs, Georgia. Mr. Foxworth will be living with his mother on Peachtree Street downtown, so they would not be living in close proximity to each other if she is granted bond in this case, Your Honor.
Was there another, on the other case you had, was there a no contact with him on any of the other cases, or no?
No, Your Honor. My understanding is that none of those charges.
These cases ever involved him, so there's nothing like that out.
No, Your Honor.
You have any questions for Mr. Norwood?
Who called 911? Mr. Foxworth? Is he sworn in? Or
Yes, he's been sworn in.
who called 911?
I did, Your Honor. Sir.
Okay, that's my only questions. That's my only question right now. As far as the state's position on bond, Your Honor, with respect to Ayala, we appreciate the relative lack of felony convictions. There is history, there is a multi-state history here. We would submit there is danger posed to the victim here. The allegations here is there was a visible injury on the victim's face caused by being struck with the object actually isn't identified in the warrant, but this defendant was struck with an object that caused a visible laceration, a curved laceration, possibly a beer can was used. So we would submit based on that allegation, there is additional risk here of not only reoffending, but also a danger posed to the victim. So we would ask for nothing lower than a $15,000 bond on count on the aggravated assault. We will defer to Your Honor on the marijuana that was found on the person once taken into custody. That's about 6 grams of marijuana was brought into across the guard lines at Rice Street without the consent of the jailer. It was concealed upon an initial search. But that's the state's request. We would request no further contact, but of course we'll defer to Your Honor on this matter and nothing further at this time.
Last few words, Mr. Johnson.
Yes, Your Honor. Just wanted to say, as it relates to the marijuana in this case, Your Honor, obviously under some circumstance, my client had this marijuana on her person when she was taken into custody. So she did not have the opportunity to dispose of it or anything else. She didn't leave it. She didn't attempt to hide it in a car or anything else like that. It was on her person when she was taken into jail. That just happened to be a circumstance of her arrest. And I do not believe that imparts any type of criminal intent to intentionally smuggle drugs into the court, into the jail, Your Honor. So we will defer to the court's bond as it relates to that. As stated before by the state's recitation, that the allegation that my client was that my client allegedly struck the victim with a beer can. In this case, we don't know if the beer can was full or anything else like that. That's a normal item to be held around the house. So, Your Honor, if that is the case, that does not show that she is a threat to the community in any way. There is no allegation. She has no violent history whatsoever. So nothing in her multi-state cases alleges that she goes around striking individuals or anything else like that. At best, we can say that this is an isolated incident. And even though we're not dealing with guilt or innocence at this point, we can still say that this is possibly based on her criminal history, an isolated incident. Whatever punishment may come from that is down the road, Your Honor. Right now, as it relates to bond, Mr. Foxworth is on the screen. He indicates that he wishes for no violent contact. There's been no prior history of any domestic involvement between these two parties whatsoever. So as such, Your Honor, we will reiterate our request for a bond not to exceed $15,000 total.
Just very briefly, if I may respond to that, Your Honor. Well, yes, I would just state that given the domestic nature of this incident and based on the drinking here, there is additional risk of danger to the victim here, Mr. Foxworth, as well as a risk of reoffending. So we would also ask for a no alcohol while out on bond, no drugs or alcohol while out on bond here as well. And again, given the domestic nature of this incident, the state would submit there is a risk of obstructing or frustrating justice if the defendant were to make bond. Nothing further from the state.
So, Ms. Miriam, I'm not going to try to pronounce your name again because I'll just destroy it each time I pronounce it. So please forgive me. Okay. No drugs unless prescribed, no alcohol, no weapons for the entirety of this case. Okay, until it's over. 250 on count one, $250, 250, and then 14,500 on count 3. So that's a total of $15,000 good bond. No further violent contact with Stephen, Steven Foxworth. Right, but you can't. No communicating about this case. So, ma'am, this means if Mr. Foxworth comes up and says you're telling him to drop the case, that's a violation of your bond condition, okay? All right, but you can't communicate about any of that. And Ms. Miller, make sure you note on there that the victim appeared and testified, please, ma'am. All right, thank you, ma'am. Best of luck to you. Thank you, Mr. Johnson.
Thank you, Your Honor. May I be excused?
Yes, sir.
Did this case receive a reset date, just in case we still need to do a preliminary hearing?
What, do you think she's gonna make it, or do you want to just file a motion?
Well, at this time, Your Honor, I do believe that based on the amount of the bond that Ms. Olamoja will be out of jail probably within the next week. If she's still having trouble making the bond, I will speak to the court to try to get back on the calendar for the preliminary.
Okay. All right, that's fine.
Thank you.
You want, okay, now do you want, what, you need anything from the Officer Smith so Mr. Clement can go about his business?
Oh, let me go back.
Officer Campbell on the James P. Smith case number 2.
Investigator Paul said advised she is working on a status for Officer Campbell. We don't have an update yet. She is working on it.
All right, sorry, Mr. Clement.
Hey, Judge, madam, what was the total amount of that bond, the last bond?
15,000.
15,000.
Thank you, Mr. Parkworth. Stay healthy and safe. All right, so then we'll go ahead and you can get, did we have back out here last time, John Diamola, is that who we had out?
Judge, it is reverse, Damalola John. John is the last name.
No, it's reversed.
Yes, Judge.
Okay, never know. Okay, so
It's actually easier to just say Mr. John rather than Mr. Damalola.
okay, so is it John, is it, which way is it? So is he out there yet now?
Yes, Damalola is his first name. John is his last name.
Yeah, okay, maybe they need to change it on there. Get him out. All right, this is 22 CP 214458 Damilola John. I'm sorry, sir. 63 days without indictment. He got ag assault, armed robbery, possession of a firearm or knife for the commission of or attempt to commit certain felonies. All right, we'll go ahead with the prelim, let Ms. Mann do her thing, and then after that, we're going to address bond.
Your Honor, I am waiving the prelim and like to be heard on the matter of bond.
Right, Mr. Norwood.
As with respect to Mr. John.
Okay. Mr. Norwood.
Yes, Judge. We have our officer here, but he's still here for position 5 as well. So I'm not sure what Attorney West wants to do with that one.
You know, if I may just come in here, I just want to see if we can do a bond on that case, Your Honor. If there's a bond, then we can waive the prelim in this case. So chances are we may not need.
So if y'all get bonds, y'all want to waive the prelims. If you don't get bonds, then you want to prelim, right?
Yeah, I'm just following up with this in writing as well. Is there a sheet that is filled out when the defendants waive the prelim, or?
There should be. I think they're up there on the bench. If one of y'all want to walk up there, when you look, it's on the left side, because they got to get their client side up on the left-hand side. Press it, kind of near where that
Oh,
there's some form up there you can reach.
I'm gonna start doing those just to make sure. Appreciate it. Then once they sign, make sure it's fine. All the other ones I'll have notated, but I'll try and get them to fill one out as well.
Yeah, you can probably send one to Ms. Dorfman. I'm sure she'll probably.
Yes.
It's on the record, but maybe send it to Mr. Johnson too.
This is the signature waiting here.
So if Attorney West, I'm not certain, Judge Manning, what the Attorney West's decision, is he also waiving the preliminary?
Oh, yeah. I mean, I believe I did announce that, Counsel. I'm sorry. Maybe I'm not clear on it. Yeah.
Okay.
Clear. So we'll just go with a bond here.
Stand by, y'all. So I don't know who's here at iPhone 11. Who is here with their screen name as iPhone 11? All right, iPhone 11, I'm removing you from this meeting. When you figure out how to change your screen name to your first and last name and go back up, we can allow you back in the meeting. No one's allowed in this hearing with iPhone 11 as their screen name. Go. All right. So it's okay, we got them out there. So we've got CP 214458, Demilla John, got 63 days without indictment, aggravated assault, armed robbery, possession of firearm, knife during the commission of certain felonies. Is this man here? Let's see, Ms. Mann, whenever you're ready, pre-trial. And I'm sorry, Ms. Cromwell, she's working 2 courtrooms right now.
Not a problem.
Ms. Mann, position 4.
Position 4.
Yes, ma'am.
Okay. I don't know if you can hear me. Let me click off the other one, Your Honor.
I can hear you.
Okay, I wanted to click off of that other one so you can hear me.
Okay.
Position 4 is on John. There is 2 cycles, prior cycles, Honor. The first one's 12/26/17, theft by shoplifting. That case was convicted, bond forfeiture for 2018. Next cycle, 12/5/22. I don't know if this is the case we're on today, Your Honor, but there is a aggravated assault, charge 2, armed robbery, 3 felony statutes, all that it has, Your Honor. GCIC, NCIC has nothing further.
All right, thank you. Go ahead, Ms. Cornwell.
Thank you, Your Honor. Before the court is Damilola John. He is 28 years old. He's lived in Georgia since 2010, has a residence, his own apartment in Buckhead and Roxborough Road Northeast. He works as an independent IT contractor and was supposed to start school, an IT school, January 5th, 2023, but unfortunately he was in custody. He completed college in Alabama. He has had no felony convictions. The theft by shoplifting.
I wasn't convicted.
Okay, I do not believe that was a felony conviction, but a misdemeanor, theft by shoplifting. I've spoken with Mr. Norwood prior to this hearing, and we had a brief conversation about bond, and he was indicating that if he were to make any recommendation, it would be in the area of $60,000. Mr. John can't make that amount. And I would ask the court to set a lesser bond. I believe that he meets all the IALA factors for a bond in this case. And more importantly, Your Honor, I have Courtney Russell, the victim in this case, who is on this platform. And she has expressed not only to me, and she can confirm with the court if the court would like to hear from her. Courtney, can you take the unmute and show the video, please?
Ms. Russell, if you could turn your camera on, take yourself off mute. Ms. Russell, if you could please turn your camera on and take yourself off mute.
And there she is.
All right, Ms. Russell, stand by. Do me a favor, raise your right hand for me. Raise your right hand. Do you swear a firm testimony you're about to give is the truth, whole truth, nothing but the truth?
I do.
Okay, if you just stand by and don't say anything unless somebody asks you a question, okay?
Judge, I've spoken extensively, actually, with Ms. Russell, and she has expressed to me as well as to the state, different people on behalf of the state, that she has no interest in prosecuting this case, that it was a situation that just, the charges sound vastly worse than the circumstances that are believed to have given rise to the situation. But she has no interest in having this matter prosecuted against Mr. John. And she would certainly, until this matter can be resolved in some fashion, would like for him to be released on bond. And she has expressed that she's had no violent incidents with him before, no incidents involving firearms with him before, and would like for him to be given a reasonable bond in this matter, Judge. It's my understanding that he could make a bond somewhere in the area of $35,000. So I would ask that in breaking it down by charge, 20,000 for the armed robbery, 20,000 for the armed robbery, 10,000 for the aggravated assault, and 5,000 for the possession of a firearm. Judge.
Ms. Russell, is this, it says in the warrant that you recognize one of these who's your ex-boyfriend. Is Mr. John your ex-boyfriend?
We were actually dating. Well, yeah, we were dating at the time of the incident.
Okay, so he's your ex-boyfriend now.
I haven't spoken with him. No, I mean,
hold on. I'm not trying to make you break up. I'm just reading the language in here. In here. It says.
If I may interject, Judge, I'll tell you, she's had no contact with him pursuant to orders that she's had no contact with him since this event. So she's not talked to them about the status of the relationship. And frankly, Judge, I believe that this all stems from really an attempt to see her phone to see whether she was communicating with other people, boiled down to the best I can. So I
was just going to interrupt you real quick. So I was just reading from the warrant because it says when there was a show up, she identified one who was her ex-boyfriend. Maybe they put those words in your mouth. Maybe they didn't, Ms. Russell. I don't know. All right. What says the state?
Oh, yes, Jeff. If I could just briefly ask Ms. Russell, good afternoon, Ms. Russell. On the December 5th, 2022, who called 911?
I did.
Why did you call 911?
Because I didn't know who had robbed me.
Okay, but you were robbed.
Well, at the time, I didn't know the person who came up to my vehicle. I had never seen him before. And when the police drove me around to ID both of them, that's when I realized who was in the driver's seat.
Okay, and you spoke to Ms. Botu today from our office?
Is that Misty?
Yes.
Yes.
What did you tell her?
About what? I mean, we spoke about a lot of things. About what?
If there's anything you would like to share about your conversation, is there anything you would like to say about that conversation right now with the judge on the line?
That I would like the case dismissed.
Okay. Nothing further from the state at this time for Ms. Russell. With respect to the note I received from our victim witness advocate, Ms. Russell did confirm that her and defendant Damilola were in a relationship. She stated they have not been speaking due to the no contact order from the judge, said at first appearance is my understanding. She has advised she would like to continue a relationship with the defendant if able to. So yes, there is a pre-existing relationship here that the state that does know about. With respect to Ayala, we'll submit there is danger posed to this victim by Damilola, defendant Damilola and Jaga. There was a firearm involved here. There was a pointing of the firearm. It wasn't just a cell phone that was taken. It was an iPhone, a red purse, 4 checks with the victim's name and other miscellaneous property from the immediate presence. We had a black Smith & Wesson. There was use of a car offensively to block this defendant in. and not be able to escape. She was on the phone with the cousin and advised that she thought somebody was following her when she was asked to or demanded to provide the passcode for the phone. She did comply, and she also gave her debit card pins, including and of course a phone and purse. So we're asking for $20,000 as advised to Attorney Cornwall, $20,000 on the aggravated assault, $20,000 on the armed robbery. I'm willing to ask Your Honor not to go anything lower than $15,000 on the possession of firearm or knife during commission of a felony. And we do respect that there is a relative lack of criminal convictions here. And we would submit there may be a risk of reoffending given the prior the shoplifting, the theft by shoplifting charge. Nothing further from the state, Your Honor.
Anything else, Ms. Cornwell?
No, Your Honor, I believe that there could be, I mean, he's obviously complied with the conditions set at first appearance of no contact, has not tried to reach out to Ms. Russell. She has indicated wanting to be able to have contact. I would leave that to the discretion of the court. Certainly no violent contact of any nature between the two. They don't live together. They don't share children together. So he would be returning to his own residence if given a bond in this case that he can make.
So, Ms. Russell, I appreciate everything you said. However, right now I think I've done 18,000 domestic violence cases since January the 1st, 2018. And several people, and hopefully you're not going to want to be one of those statistics to get hurt, but there's a difference between asking to see your phone, you not letting him see it, getting somebody, blocking you in, pulling a gun and doing all just to see your phone. So I'm going to right now, we'll put no further contact. You guys figure this out, but I don't want you having contact. I'm just trying to protect you, Ms. Russell. No further contact with Courtney Russell. I'm sure you guys are going to do what you want to do, Ms. Russell, but I'm saying no further contact. If you can't protect yourself, and I'm going to do my best to protect yourself. Stay away from 805 McGill Park Avenue Northwest. No drugs unless prescribed, no alcohol, no weapons. $20 ag assault, 20 armed robbery, and 10 on the firearm by possession of a firearm or a knife during the commission of certain felony. Absolutely no contact with her, sir. I'm sorry, none. This isn't allegedly what you do to get a phone or not get a phone. It's not. That's just not what you do. So, Ms. Russell, that's going to be my thing. You can work out with the DA's office, whatever you want to do, but right now I'm going to protect you as much as I can. Best of luck to you, sir. Ms. Cornwell, do you want to have the prelim?
No, Judge.
Okay. All right. Best of luck to you, sir.
Thank you.
Okay, thank you. I've got Ahmed Jaga. Mr. West.
Yes, Your Honor.
And I did just receive an update on Officer Campbell. He will be here in 30 minutes. I'm not sure why the delay. I'm trying to get an update on that as well. But
you can sit there, you can turn off your camera, you can walk away, you can, 30 minutes. If you just want to listen out, we'll yell for you when he shows up.
Okay, sounds good. Thank you, Your Honor.
Sure, thank you, Mr. Clement. Thank you for being patient. All right, so we'll bring out Ahmed. Is it Jaga? Jaga? And Mr. West, are you wanting the officer to hang out to see if you still want to prelim?
No, Your Honor. I believe, I'm sorry to cut in, Your Honor. I don't want a prelim. I believe we'll waive that.
Okay, you're gonna wait. All right, so that.
Yeah, we're gonna waive the prelim, Your Honor.
Okay.
We'll
Let the officer go.
yeah, we'll ask for Officer Frank to be excused now.
Yes, sir. Thank you, Officer Frank. Stay safe out there.
All right, then. Thank you. Usually have cars, but yeah, stay safe out there. Let me know if you need anything. Yeah, all right.
Yeah, and you can send one of those forms to Mr. West. I'm sure he'll.
Yes, I will do that. I'll scan them in once I get back to the office. I'll send it by email.
All right. No problem. Thank you.
It does need your client's signature. Did you want me to give it to your client?
Yeah, I mean, he can sign it. I believe my client should be in there.
All right.
Mr. West, on here before he gets out here, we got a Milwaukee, Wisconsin address. Is that a correct address for your client?
But he's got a local address, Your Honor. He's got a local address, which would be just the same thing as the prior. That's 3450 Roxborough Road, Atlanta, Georgia. That's 30326.
Okay. On the booking sheet, it just said Milwaukee, so.
Yeah. He moved down here from Milwaukee. That was a while back. So it's his address here is 3450 Roxborough Road.
All right, I just have to go by what's on the pretrial report and the booking sheet, but I guess he's probably glad now that the polar vortex came through, right? He's not up there. And I talked to my buddies in Vermont, and they said it was like 50 below. It only got to 50 below when I was there, so I'm glad I wasn't there then too. 50 below.
Which one? Jaga, or
Yeah,
what was your question? Position 5, Ahmed Jaga. Yeah. The co-defendant. I think we're gonna get him. He should be up shortly,
Is he a co-defendant in something? With, oh, he's a co-defendant with.
They're both in the same case, yes.
They're both in the same case, y'all.
John, okay.
And Judge, on position 2, we may be waiving. My client needs to come out and he would need to make that decision because I have talked to ADA Norwood and he does have a recommendation. We may just want to be heard briefly on bond, but my client would need to waive that and not me.
Okay. Well, Ms. Miller, put no further contact with the co-defendant on these two. So
Oh, yes.
And then D'Amelia John, no further. Ahmed Jaga can't have contact with John D'Amelia.
Yes, Judge.
Thanks. All right, there he is. Are you Ahmed Jaga? I'm sorry if I'm mispronouncing that.
Yeah, Ahmed Jaga.
All right, so it's 22 CP 214458, 63 days without indictment, armed robbery, ag assault, possession of a firearm or a knife during the commission of or attempt to commit certain felonies. See, is Miss Mann here? Miss Mann.
Yes, sir.
Young lady,
That's position 5. Ahmed Jaga. You're on mute, Miss Mann. Ms. Mann, I'm sorry, oh, shoot.
Your Honor, you wait for me?
Ahmed Jaga. Number 5.
Okay. Ahmed Jacobs, Your Honor, GCIC has no record found other than what he is before you on today.
All right, thank you. Go ahead, Mr.
No,
Clement.
for nothing further.
I mean, Mr. West, sorry, Mr. West.
All right, good morning, Mr. Jaga is a 25-year-old young man who resides here in Atlanta at 3450 Roxborough Road. He has no prior criminal arrest or prior criminal conviction other than the one that is facing here this afternoon, y'all. Mr. Jaga, he's a college graduate. He just graduated from college and with a bachelor's degree in international relations. And he works for a security company. And it was actually prior to this incident here, he was supposed to go into the Navy, So Mr. Jaga, he's not a threat to the community and he's not a threat to the society, He's not a danger to the community at this time, And based on what prior counsel said on behalf of Mr. John, I also spoke to the victim in this case. And she also told me that she has no intention of moving forward with this case. And she let me know that, she was not aware of both defendant in this case at the time of the incident. And if she was aware of it, she would not have done what she did. And I did tell her that whatever she wants to do, she can communicate that directly to the DA's office in this case, And again, like I said, Mr. Jaga has no prior criminal arrests, has no prior criminal conviction. This is I don't know how to describe what it did to me. It's pretty stupid. But again, without me admitting to anything in this case, but at the same time,
Allegedly stupid, then, Mr. West. It's allegedly stupid.
Well, I mean, it is because in me talking to these guys, it makes absolutely no sense. If you want to find out whether somebody is cheating on you, just call them and say, hey, why you doing it? Come on. But to me, I mean, these young guys, especially my client, is not a criminal, never been arrested before, never been involved in any criminal activity except for this incident that happens that, according to him, he didn't even know that they were committing the crime. So he just thought, they're approaching a friend. I'm like, well, you don't approach a friend like that. None of that circumstances, And again, like I said, he's a college graduate. He was actually supposed to enlist in the U.S. Navy, this last month. But of course, that is on hold because of what is going on here at this time, So as a result, we're going to ask that Mr. Jacob be granted a bond, a reasonable bond in this case, and we're asking that he be granted a bond in the amount of $30,000, which we feel, should be, enough in this case, based on the fact that he has no prior criminal arrest, he's not a threat to society, and he's not a danger to the community. And if granted a bond, he's going to reside right here in Atlanta. And the address that I provide, which is 3450 Roxborough Road, and that's in Atlanta, Georgia, 30326, Judge. And therefore, Judge, we're going to ask that to be granted a bond in this case,
All right. Go ahead, Mr. Norwood.
Yes, Judge, I would just submit the same argument. We would submit there's danger posed to Courtney Russell. We appreciate the lack of no history here. However, upon the felony stop being conducted on the vehicle that was used in the robbery, the victim's checks were found in this defendant's back pocket. That's information I have. We submit that is indicative of being a part of a crime here, respectfully, given counsel's argument, this defendant didn't know he was part of a crime, and the purse was in plain view that was taken from Ms. Russell. Both defendants were positively identified in a show up by Ms. Russell. So that is the state's argument. We would ask for the same amounts here, $20,000 on each felony, $15,000 on the possession of firearm or knife during commission of felony, no further contact with Dami Lola, and no further contact with Ms. Russell. Stay away from an incident location. Absolutely no weapons. Nothing further from the state.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 805 McGill Park Avenue Northeast. No further contact with Courtney Russell. No further contact with your co-defendant, Damilola John. Sorry, I said that 100 different ways. No further contact with him, sir. So you can't have any contact. And I'm sure Mr. West doesn't want you to contact him anyway. Right?
Yes, yeah.
All right, let's see. So I'll do 10 on each count for a total of $30,000 good bond.
Thank you.
I know I was in the Army, not sure the Navy's gonna take you right now, so too bad, but can't have any contact with either one of those people. Best stay away from them and do what your mama says. Best
All right. Thank you, Judge.
Yeah.
All right.
How much you say?
So you give him the way that Mr. Jager.
Yes, ma'am.
Sorry, did you, did he sign that, Mr. Norwood?
Oh, yeah.
No, he did not. Sign, yes. Yeah. Thank you, Your Honor.
So he'll know to sign.
So we can get some of it.
You can tell him what it is, Mr. West, if you'd like.
Okay, Your Honor, that's fine.
And Mr. West, I'll tell you what it is really quickly, Mr. Jacobs, so you'll know what you're signing.
Yes, Judge.
2/6/24.
All right. Thank you. Thank you. I will scan this and send it to you, Attorney West.
All right, thank you. Appreciate it.
Thank you, Mr. West.
All right, thank you, Your Honor. May I be excused? That's all I have, Judge.
Yes, sir. Good to see you.
All right, thank you, Judge. Good to
All
see you again.
Thank you. So, Mr. Clement, I guess we'll just stand down till we see that officer come in. We'll just yell for you, I guess, when he gets in here. As long as you can
Yes, and just for the record, it seems that They put his subpoena in the wrong mailbox. That's what I have as the reason for the delay. So we just wanted to put that on the record as it wasn't a problem on our end. But I do believe he's on the way now, and we can proceed with a hearing unless I believe Attorney Clemens said he was thinking about waiving. He just needed his client to come out and make that decision.
Oh, okay. You can
That's
bring
correct, Your Honor.
bring James Smith out there.
Can we bring up position 2? Smith, yes.
I don't know with you being away, how you could talk to him privately, Mr. Clement.
Well, we talked about everything on Saturday, so I just want to, obviously it's his decision to, waive his preliminary hearing, but I've advised him on that.
Okay. Thing.
Hey, James, this is, I'm your attorney. We talked on Saturday and, we talked about possibly waiving the preliminary hearing to be heard on bond so you could get out on, so you could potentially get out of jail. And that if you are granted bond and you make bond, there's no right to a preliminary hearing. I wanted to see if you wanted to go ahead and waive that preliminary hearing to be heard on bond right now.
Yes, sir. Whatever you feel is the best course of action, yes.
I think that would be the best course of action in this case.
Yes, sir.
So we'll just waive preliminary hearing, Your Honor, and be heard on bond.
Okay. I guess somebody will contact that officer.
Letting Investigator Pauls know right now. I can contact him as well if you wants me to make the call.
Okay. So what he's getting you to sign there is waiving your preliminary hearing, Mr. Smith, and then we're gonna send it to Mr. Clement. He'll sign it too. Okay?
Yes, ma'am.
All right, Joe, we're ready.
Okay. This is position 2, 22 CP 214318, 70 days without indictment. Got aggravated assault with a deadly weapon. This man.
Your Honor, there are 9 prior arrests, last one being 3409, marijuana possession less than 1 ounce, not on docket. 4/3/2003, parole violation, time expired on that, Your Honor. 1/18/03, purchase, possess, control, drug must be named. Second charge, marijuana possession less than 1 ounce. Third, criminal trespassing. All 3 not presented to the grand jury, Your Honor. There is a 2502 probation violation, first offender, convicted. 2002. There is a 7/18/01 charge, Your Honor. Would you like to hear that? Or have you heard enough?
I'm good. Thank you so much. Go ahead, Mr. Clement.
Okay.
Yes, Your Honor. Mr. Smith is a loving husband and father. He's married to Nikki Smith, who is on the call today, and they've known each other for 25 years. They have 3 children together, a very successful 26-year-old daughter named Kyra Vining. And right now, Mr. Smith is raising his 2 sons, Jalen Smith, age 17, and Jarvis Smith, age 16. They both attend Maynard Jackson High School, and they're very successful as well with the support that Mr. Smith has given them. Mr. Smith is highly involved in the community. He spends a lot of time giving back to the Peoplestown community. He helps out with the Emma's House, which is an outreach program of the Episcopal Diocese of Atlanta. Mr. Smith has been working at the Atlanta Signal Company for over 8 years now. He's part of the manufacturing team, and he helps produce a variety of tools that let our roadways run as smoothly as possible in Atlanta and throughout the greater United States. He doesn't have any violent criminal history, as you heard from the recitation of criminal history from Ms. Mann. The last arrest he had was 13 years ago, and it was a simple possession case, and everything else is over 20 years old. Mr. Smith and his family no longer live in the incident location at 1044 Washington Street. As far as the incident goes, the alleged victim in this case, Walter Lovett, was a chronic drunk and a constant harasser of people in the neighborhood. And I've talked to people throughout the neighborhood that, have confirmed this. He was always kind of starting fights and everything. And I'm at a slight disadvantage because I don't have any of the discovery yet, but it's my understanding in this case is that Mr. Lovett started an altercation, a physical altercation ensued. In the defense side of the case, would be that the gun was possessed by Mr. Lovett and it accidentally went off. I think Mr. Lovett shot himself. As far as the Ayala factors go, my client doesn't, pose any significant risk of fleeing the jurisdiction or failing to appear. There's no history of FTAs. And the only reason he didn't turn himself in on this warrant is that he was never made aware that this warrant had even issued. The APD officers went out there to the scene that night, talked to my client's wife, Nikki Johnson, and that was the extent of the contact that happened by APD. They just never followed up. If my client knew he had a warrant, he would have turned himself in. For the second factor, you'll have to excuse me, Your Honor. I have a upper respiratory thing right now, so.
Feel better.
If you can't understand me, let me know.
No, I hear you. I feel better. I had to show myself.
For the second factor, I don't believe that Mr. Smith possesses or poses any significant threat or danger to any person, to the general community, or to any property. He doesn't have any violent criminal history. He doesn't live near the alleged victim in this case. They don't live in the same apartment complex anymore, and any bond conditions satisfy those. For the third factor, excuse me, I don't believe Mr. Smith poses any kind of risk committing a felony pending trial. I just don't, there's nothing in his criminal history to suggest that. He's been, minus that simple possession case. He doesn't have a blip in his record in 20 years. That's been, his adult life there. And for factor 4, I don't think he poses any risk of intimidating witnesses or obstructing justice. Once again, there's no history of this, and I don't think there would be anything to suggest this. In this case, we're asking for an unsecured judicial release, Your Honor, due to my client's lack of any violent criminal history, his engagement with the community, his support by those in the community, as well as the circumstances surrounding this case. I think that he's an excellent candidate for bond, and the pretrial services report, excuse me, recommended him for an unsecured judicial release. He's a fantastic human being, and I don't think it's someone that we want removed for community. So defense would be recommending an unsecured judicial release. It's my understanding that the state would be recommending a $30,000 bond. We would be asking, for Your Honor to grant my client bond an amount that you deem appropriate. Thank you.
And I understand this incident was March 21st of 2020.
Yes, Judge. Taken into custody about 70 days ago is my understanding. He was working at 2755 Bankers Industrial Drive. Some officers from Doraville got information about his employment there and located him and took him into custody without incident upon a felony stop based on the information they had in the car. With respect to the state's information right now, the state is in touch with the victim. The allegation here is 2 gunshots to both legs while running away. The defendant, the victim, Walter Lovett, lost feeling in both feet. He has a metal plate in his right calf. He was out of work for several months. He stated that him and the defendant had gotten into a fight days prior to the shooting over the defendant selling drugs in the building where the victim lives. And the victim got the best of the defendant. And then days later, the victim states that he sees the defendant, and that's when Smith, the defendant, opened fire on him, shooting him in both legs while running away. The victim would have been on the call today, but apparently had another issue, so that they weren't able to make it today. But our office is in contact with Walter Lovett. He is opposed to bond. However, if Your Honor is inclined to grant a bond, the defendant isn't at 90 days yet, we would submit to Your Honor, this case is undercharged. In addition to possession of firearm by a convicted felon, there's at least one convicted felony, 2001. There was a parole violation for that as well. There should also be possession of a firearm during commission of a felony. And here we would submit, in addition to the aggravated assault, there would be aggravated battery due to substantial loss of use of the feet. My understanding is the feeling in the victim's feet was coming back, but they just got into a car accident recently, which is why they weren't able to be here today. That's what our victim advocate told me today. There was a altercation days prior to the shooting. And then as a result of the shooting, that's when this defendant pulls up and unloads on the victim, and substantial injury to the defendant. This was in March of 2020. We would submit there is significant danger posed to the victim and the community. We would submit there is a significant risk of reoffending pending trial. I'm not sure if the defendant has a new address, but there may be some additional risk of intimidating the victim or otherwise obstructing justice should the defendant make bond. And I'm not sure what the probation or parole situation is now, but this defendant is a convicted felon and has showed disregard for that status. So we would submit there is a risk of not returning to this jurisdiction to face that charge, or at least take accountability for what transpired in March of 2020. So I would ask Your Honor to set a bond in an amount that's reflective of this case being charged, but I'm asking for just the one charge encounter, nothing lower than $30,000. That was advised to Attorney Clement today.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Walter Lovett. Stay away from, on the warrant it says 1038 Washington Street, although Mr. Clement, I think you said 1040.
I have 1038. I'm not sure if it could be
1038
different.
Washington Street. I think it said no drugs, no alcohol, no weapons. Where does he work, Mr. Clement?
American Signal Company.
What is it? What is that? Okay, what does he do? I don't know.
He's a manufacturing tech that helps produce all sorts of different signs and roadway equipment.
All right. So we're gonna go ahead and give him an ankle monitor. Maybe this will just bring some, and it could be paid for by the corporate project. 24-hour curfew, court, lawyer, medical, and work. So as long as he supplies his work schedule, he can go to work. And of course, if there's medical appointments for the children, he needs to go there. Mr. Clement, he just needs to tell you when he's going, and you tell the state and let the ankle monitoring company know. Unless he has a shift, I don't want to, as long as he's going to work, he can go court, medical, or medical for his children. He can best of luck to you, sir.
And I'm sorry, you were breaking up there a little, Your Honor. What was the amount of the bond?
$30,000 good bond.
Okay, thank you, Your Honor.
All right, best of luck to you, sir.
Yes, ma'am. Thank you.
Thank you, Your Honor.
All right, thanks. That is it for today, right now?
That's my understanding. That is everything. I have the signed waivers. I think most of the situation we're